Hello, my name is Russell J. Fishkind, and I'm a partner at the law firm of Saul Ewing. Our firm currently has over 250 attorneys in 5 Mid-Atlantic states. I'm a member of the Personal Wealth, Estate, and Trust Department in New Jersey and New York. In addition to estate and business succession planning, our department represents beneficiaries, executors, and trustees involved in contested estates. One common situation in estate planning centers on elderly persons who struggle with mental capacity issues and may or may not have an effective power of attorney. Too often, their children have opposing viewpoints as to how the parent should be cared for and how the finances should be managed. In the following example, Amy's experience illustrates the importance of a power of attorney and the necessity to appoint a guardian.
At first it was just little things, like he'd call me by my sister's name or forget what he wanted for dinner. But then after my mom died, my dad seemed to get so much worse. And now he's forgetting to take his prescriptions and even forgetting to open his mail. The other day I had to call the water company just to make sure that they didn't shut off his service. I'm starting to get really worried about him.
Well, you know, I went through the same thing with my mom, but at least I had my brother there to help me get through it. You can't count on your sister either. You gotta be proactive. Do you even think he could handle his own assets?
No, and that's what worries me too. The other day I spoke to his financial advisor, and he said my dad called him trying to sell stocks that he didn't even own.
We're gonna have to set something up for him. Are you willing to take the responsibility, though?
Of course, he's my dad. It's my sister that's the problem. And with Dad's assets involved, this is going to be a real battle.
Could a power of attorney solve Amy's problem? In the example we just saw, if Amy's father had given her power of attorney, then she would have a legal basis for taking control over his finances. However, since Amy's father is already suffering from the mental degradation of old age, she may want to consider an option known as guardianship. In a guardianship proceeding, a petitioner asks the court to declare that an adult is incapable of making decisions in their own best interests. An individual can be declared incapacitated if they are impaired by a physical or mental illness such that they lack sufficient capacity to manage their own affairs. Proof of incapacity requires the following evidence: written evaluations by 2 physicians, the report of an independent court-appointed attorney, and an affidavit from the petitioner. If a person is determined to be incapacitated, the court will appoint a guardian. The order of preference for selecting a guardian is a spouse or domestic partner, heirs, friends, and in the absence of all of the above, the office of the public guardian for elderly adults. In our example, since Amy's mom has died, either Amy or her sister is next in line to become her father's guardian. Oftentimes, family members fight over who the guardian should be, and the courts must make this determination based on the best interests of the incapacitated individual. Once selected, the guardian will receive letters of guardianship that enable him or her to make appropriate decisions in providing for the living arrangements, medical care, meals, transportation, socialization, and recreation of the person under guardianship. Courts may also divide the duties of a guardian between decisions over one's person and property. For example, the court could decide that Amy may determine where her father will live, but not how to manage his finances. Since a guardianship proceeding takes time and can be expensive, each case must be carefully reviewed with an experienced attorney before filing for judicial intervention. If you feel that a guardian should be appointed for a loved one, you should seek a competent attorney to guide you through the legal process.